righty, I think we're all set here. So we'll go ahead and get started. So Andrea, welcome. Thank you for meeting up with us today and being generous with your time. It's about 20 past the hour where I am. So the hope here is that we can have kind of an informal conversation with you about the talk that you just gave for 20 minutes or so. So I'll just kind of hand it over to you in a second. I'm just going to ask a question or two, and then you can kind of take us where you want to go. But before we do, let me just invite anyone who's in the room as well, unless Andrea, you mind, but my guess is knowing you, you don't, to ask questions. So cool. So you can just type directly into the chat if you have a question. I see Natalie says, as a former foster youth, she'd like to thank you, Andrea, for your message already. So thanks for that, Natalie. Feel free to type into the chat any question or comment that you have, and I'll just read it to you, Andrea. That way you don't have to keep an eye on both the chat and be talking at the same time. Or anyone can just interrupt me as well. If you just want to turn your camera on and turn your microphone on and ask a question, I'll be quiet and you can have at it. So know that this is sort of an open forum. I'm just in the sort of interview seat for as long as you all let me be. So Andrea, thanks again for the talk. Let me just start off with an invitation to you to sort of bring to the front the core, the kernel, the golden nugget, whatever it is. What do you think that we should cling to as an audience based on what you just said?
Yeah, sure. Thanks. And thanks everyone for joining. I really appreciate and also you guys having me. So I think that what I would say to cling to is that there's a presumption now. There really needs to be a presumption that the young person, the child, is going to be present at the dependency court hearings. It's just been too long that we have said, there needs to be a reason. Does the child, have something specific to say? Is there a question? No, I mean, these hearings should not be held if a child isn't present. And so, and along with that, the presumption that better decision making is done when there's a child present. There's better advocacy when a child is present. And so just sort of that mindset change. So that's what I think that's what I would say is the main thing.
Got it. Thanks. I see a question came in the chat as well.
I can't hear you, Andy. Sorry.
No problem. Is that any better?
Yes, definitely. Okay. Now I hear you.
I think I might have accidentally hit my double mute button. I saw a question come in the chat here from Susan. She says, what steps need to be taken in order for us to get children into the court proceedings?
Yeah, sure. So it sort of depends on what your professional position is with respect to the court. So a couple of things. One, CIP directors, kind of looking at your trainings and at your policies. What is it with respect to having kids in the courtroom? Judges, like my judge will ask at every hearing, where is the child? Like there needs to be an answer. People need to be prepared to say where the child is and why the child isn't present. In Maryland, there is a rule that a judge must consult in an age-appropriate way with a child at least once a year about the permanency planning hearing. So there's no exception. So a child has to be present at least once a year. And so I think, again, depending what your position is and I used to be a child's attorney. And so I would insist that my client was there at every hearing. I'm now an agency attorney. And so what I say to my clients who are the social workers is the only people that can waive the child's presence is the child's attorney. We need to make sure that the child is present. So I think it depends on what your position is, but I think those are some of the things.
Yeah, good. Thanks. So there's a lot actually built into what you just said. So I'm going to maybe ask a few questions to unpack some of the things that you're saying, because there's so much there. There's a lot of richness. So I'm imagining myself as a CIP director. Let me just ask kind of a very practical question. Let's say I'm a total convert and I'm going, man, this is not happening in courtrooms across my state, and it needs to. What's something I can do tomorrow? What's kind of that 10% of the 100% solution that I can do, practically speaking, tomorrow to get the ball rolling, to get kids in court?
Yeah, I mean, I think, I mean, CIP directors, I think, have a lot of influence over, the courtroom and what are the judges doing, like making sure that judges have the bench cards, or because sometimes judges are a little hesitant about having kids because they're not sure what to say, and so giving them a tool, this is how you make it easier. So sending that out in terms of an email. um so and like I said, just changing whatever trainings they have, making it mandatory, that judges and attorneys go to a training or listen to what is the most meaningful way to engage young people. Like I think I said in my talk, the American Bar Association has put out a bunch of sort of literature on meaningful experiences for children in the courtroom. So a CIP director could ensure that each each judge has that, and again, like sets as the expectation, that their young people are going to be present, and that we're not really going to accept anything other than that. I hope that answers it or helps too.
It does. It does. Thank you. I'm noticing a lot of activity in the chat here. So I'll just read another question from Bridget Bauman. She makes a comment about the technical bulletin from 2012, but then follows up with, are there any plans that you know of to update that bulletin, seen, heard, and engaged children in dependency court hearings? Or are there any more recent resources that you would recommend in addition to bench cards?
Yeah, so I think is there any, so there wasn't just, okay, so I think NCJ FCJ put out in 2012 the bulletin, and I think the American Bar Association additionally put out articles that I wrote a little bit after that. The National Association of Counsel for Children has also taken this on as one of their biggest issues. And I think they put out something, and I don't remember the exact year, but I believe that they did that. I'm happy to, try and find that and pass it along to you, Andy, and so that you can send it out. And I think there was also, I think in the chat, Andrea put a link there as well.
Yeah, got it. Good. And I'm familiar with that NACC stuff too. So
I can't hear you, Andy.
How about that? Any better?
Yeah, I can hear you.
So weird. I got to do this double click thing. I apologize for that. Yeah. Okay, good. So I'll Google around at the end of our meetup today and see if I can find that NACC stuff too. I'm familiar with it and know what you're talking about. And thanks to Andrea for promptly putting into the chat the link to the NCJ FCJ stuff. A couple other questions came in while you were talking. One of them, Susan, it's like you're reading my mind, Susan. I had the same question earlier, but let's start with Deb's. She asked, in your state, are there other options beside a child being present physically that are used to engage children in the hearing?
Yep, absolutely. So the first one, this is sort of pre-COVID. What we would do is there was a sheet that the social worker and or the child's attorney would have the child fill out outside of the courtroom. So, in a comfortable environment for them, ask them all kinds of questions about how they were doing. What that sheet also did was sort of engage the child in like a meaningful discussion about what they wanted the judge to hear. And then we would give that to the judge. So in that, I usually encourage that to be used when, two times, when the judge was going to have a benchmark hearing with the child. So that just meant it was more of an informal meeting between the child and the judge, and anyone who the child wanted to be present to help the judge, get to know the child more. So it happened then, but then also if there was some reason the child didn't want to be present at the court hearing, then we would give that document to the judge. So I think that was wanted things. But I mean, since COVID, and we have been virtual, and being virtual has really cut down on so many of the barriers to having kids present. It's pretty amazing. I mean, we're all on Zoom, and the kids know how to use Zoom better than I do, and so they're there. And so it helps them, I think, because they don't have to travel anywhere. They're comfortable in their home, or sometimes sometimes my clients who are the social workers will bring the child to the agency and they'll do it there. And it also helps the child to be comfortable. So I think, having virtual hearings is a good idea. And now that we're sort of hybrid, like going back, so the attorneys are present, the courtrooms still have the cameras in them. And so now we have kids just routinely being present by Zoom now. So those are some other ways.
Got it. Thanks. And one more to Susan, and then I have another question for you that's related to something you and I talked about outside of this. But Susan asks, should children be prepped on what's going to happen in court? For example, have a mock courtroom before the actual court date.
Yeah, 100%. I mean, I think that, like I said in my talk, I mean, most of us know what the substance of what's going to happen during the court hearing. And so prepping the child for that is important. Sometimes the child's attorney will do that. But I also think the foster parent really needs to be involved in that. Like the foster parent needs to know, because they're the ones who the child is generally the most comfortable with. And so social workers need to also be talking with foster parents about what sort of the expectation is for prepping. Now, your question about a mock courtroom, I think that's super interesting. When I did that once, when we had a TPR and there was a teenager who I wanted to testify. Yeah, and we absolutely brought her in. She, saw where she was going to sit. She met the judge. She saw who was going to be in the courtroom. She was infinitely more comfortable because she was able to kind of see the environment where she was going to be. And I know that you're probably not going to be able to do that for every permanency planning hearing, actually have like a mock courtroom. But I think as a child's attorney, it is when I was a child's attorney, I would absolutely, kind of go through the things that the child was going to see. Ask me if they had any questions, tell them probably these are the things the judge is going to ask you. Do you want the judge to ask you anything in particular? So I think that really helps. I mean, obviously prep helps everyone. So I think, yes, I absolutely. But I also think, and like I said, the debrief is almost more important, that really talking to the kid afterwards about what happened. What did they think happened? Do they have any questions about it? And so, kind of like that full circle prep and debrief, I think are also important.
Yeah, one of the things that really struck me in your talk is there is a kind of elegance to the way that you describe how attorneys can engage the youth or child client through sort of preparation before court. You've given a lot of practical examples of what that can look like. The check-in during court, I thought, was a really insightful point, right? That you have to maintain sort of like your legal attention to what's happening in court, but you also have to maintain sort of like your interpersonal attention, right, to your client. And the check-ins are really
that's
nice.
What we do, and it just like that's funny that that needs to stand out for kids. With your client, we don't sort of say, well, should they be there or not? Is that going to disrupt me? No, they're there. And so I feel like we as attorneys should have the skill to be able to consult with our client and at the same time maintaining whatever is going on legally in the courtroom. I'm sorry for interrupting you, Andy.
No, not at all. I mean, this is your floor. Exactly. I couldn't agree with you more. Before I worked in dependency law, I did employment litigation, and it was like, I don't know, I'm guessing, right? Maybe a third of the hearing was, excuse me, Your Honor, I need a chance to consult with my client, right? You turn and you check in with the client. It's like, that's called being a lawyer.
Right, absolutely.
And it's this other point, so that you have the pre, sort of during and after the court hearings forms of engagement. And what I really liked about your point about reflection is we know, in pedagogy and like schoolwork, right? You know that a way to sort of reinforce and build on what's happening is to reflect on what the student has learned. And there's sort of like I don't want to go too far, but kind of a loose analogy between that experience and what you're describing, where the reflection, it seems to me like what you're saying is the reflection piece allows the client, to use your language, to process what's actually happened. But it also, at some point, the reflection turns into preparation for the next hearing, right?
For
Or
the
the
next
next,
hearing.
yeah. So there's just a beauty in the way that those things are synthesized when you think about it that way. So I think that model is really nice.
Yeah.
I'm going to switch gears just a little bit because I want to hear what you have to say about this. This is, full disclosure, it's something that Andrea and I have talked about before, but I think she has some compelling things to say about it. How much, I'll ask the question two different ways. You can go whatever way you want. How much of what you're telling me or telling us is a hearts and minds game? And how much of what you're telling us is sort of a habit or structure game? Maybe game is the wrong word, but do you see what I'm saying? Like, I've heard you talk about, at least in your talk, you have to sort of change your perspective on what you think about when you think about the child client. But I've also heard you talk quite extensively about how even if you don't change your mind, there's ways to get kids in court by changing the structures and forming new habits and behaviors. Can you say a little bit about that?
Yeah, I can. And yes, we were absolutely talking about this because, and I was watching my talk as you guys were all doing it too. And I was like, geez, I'm like passionate. Like, I felt sort of bad. I was just like, I'm like yelling at people. I don't mean to be yelling at people. And I really think that there needs to be a mindset change. Like, I really do. I just think that I'm tired of trying to convince people that it's a good idea to have young people in court, that we have more meaningful hearings when there are young people in court. So I do really solidly believe that it needs to be a mindset change. However, the other thing is just forming this habit. Like, how do we do that for people who are not quite on board? And I think it's so appropriate to be doing this on January 3rd because New Year's resolutions, and I've been sort of thinking about how to establish good habits, new good habits, and how to get rid of bad habits. And I've done a little bit of research on it and just sort of thinking about that. And what some of the research says is that we have to take away the friction. Like, what is it that is the barrier between where you are and where you want to get to in your goal? And so I think that that's important to do. So, like, just a couple of things, like that, that judges, like I was kind of saying at the beginning, that like judges at the beginning of the court hearings should be asking sort of, where is the child? That attorneys should, as a routine, as it's almost unconscious, like as a routine, have an expectation that the child is going to be present. Ask the social worker, how is the child going to get there? And so when we're like forming these habits, like taking away, any of the barriers that we have seen, I think is sort of, in what I've seen as the research is the best way to achieve getting all kids into their court hearings. Hopefully that sort of, and I'm just kind of formulating this idea as we, start the new year. But these things need to be unconscious, right? That it just should be a presumption. It should be strange that the child isn't present in the courtroom.
Yeah. Can you hear me?
Yes.
Okay, good. Yeah, and structural or and behavioral psychology, there's this concept of a trigger, and it's not like not like a gun trigger, but the idea of like there has to be when you're trying to drive behavior a certain way, you can embed trigger mechanisms to get people to behave a certain way. Facebook's a classic example, right? The like button. The like button is a trigger to get you to interact with the Facebook universe, right? Pretty
Yeah.
soon we're all going to be wearing VR and the meta reality, apparently. But for now, it's
Right.
just a like button, right?
Right.
But what's sort of, depending on how you feel about social media, what's either sort of genius or insidious about the like button is that it's this perpetual trigger that gets you to be like, oh yeah, I'm going to interact with that thing. Oh yeah, I'm going to do something about that. And what I like about what you're suggesting here conceptually is that regardless of someone's sort of feelings about whether or not a kid should be in court, if we can embed these kinds of trigger mechanisms into the court process itself, then it doesn't become a question of whether or not you agree with it, with what we're doing. This is the part where we do that, right? Where sort of it just triggers that behavior. So that's really nice. I like that idea. And your example of that is like routinely this person, they sit down, they look at what's in front of them, and they see this trigger, and so they pose the question, "Where's the child?"
Yeah. 100%.
Yeah, good. That's going to have me thinking for a while here. So I'm just noticing we're about 20 minutes in, Andrea. You probably know me enough to know that I could rattle on and ask more questions, but I won't torture you forever. Are there any parting words, or is there something that you want to leave us with as we sort of go off and do our work, marching into 2022? If we want to pick up sort of the banner of youth participation and youth engagement, youth presence in court, what would you leave us with?
Well, I think I would leave you with that really, thinking that and believing that we're not doing our jobs if the young person is not present, engaged, that the hearings are not meaningful, that we're not really holding hearings. I mean, I'm an attorney, and if I were to believe that a hearing isn't meaningful, I'm doing something wrong. So I just think that we need to really believe that we're not doing our job if the child is not present. And we're not, and you and I talked about this before, Andy, that it's not just a professional, right? It's personal, right? Like we do this work because we think that it is important for children to be safe, for them to have permanency, and for their well-being to be taken care of. Those things are not happening if they're not engaged, if they're not at their court hearings, if they're not sort of, having input with the judges that are making those decisions. So that's the thing I think I would leave folks with, that we're not doing our jobs if the kids are not present. And when they are present, the hearings are so much more thorough. They're just better hearings. People are more attentive. We talk about all different things. There's not, it isn't just a quick hearing. Like these kids like make these hearings important, and they need to be there. So thanks, Andy.
Thank you, Andrea. That was great. Appreciate it. So on behalf of everyone, actually, thank you for giving us some more of your time and talking with us a bit more about, this foundational issue in our practice and in our world and in the lives of these people's, in the lives of the people who these decisions and activities affect. So thank you for that.
Great. Thank you.
For the rest of you, we'll wrap it up here. Actually, for everyone, we'll wrap it up here. We'll have another CIP talk next month. The topic, it will be released soon over the listserv, so keep an eye out for that. We'll also share this recording and the link to the NCJ FCJ CIP talk itself later on. So again, thanks everybody that was working in the background, by the way. Stephanie and Adria, appreciate it. Great.
Happy New Year, everyone.